SJC-12501, Commonwealth v. Aaron J. Hernandez.
Mr. Quinn, good morning.
Morning, Justice Gantz. Other justices, please, the court. With me is Shoshana Stern, behalf of the Commonwealth. Thank you. The practice of wiping out a jury verdict like it never occurred is not fair or equitable. It only serves the interests of the defendant. It does not consider the significance of a jury verdict, its impact on those affected, and the integrity of that verdict with respect to our society in general. It does not consider the interests of victims in a conviction. The impact on them, in this particular case, there was an allegation of brutal murder, there was a conviction, obviously a lot of emotional turmoil and investment in the proceeding. A jury, which is speaks for the people in our society, rendered a guilty verdict that they're entitled to rely on, if it's just. That goes to really the heart of our system, the jury verdict, the integrity of it. And also, there are collateral issues that come with that, could have ramifications in non-criminal proceedings, but there's a public interest in the perception that justice is being done. There's a public interest in vindicating a just conviction. Now, I am in no way minimizing the importance of the defendant's right to have an appeal. It's a critical part of our system. I do not want to see someone convicted improperly. That's not my argument. But this doctrine does not take into account all of the interested parties that have an interest in this. It's not constitutionally or statutorily based. The court decisions in Massachusetts do not clearly state a justification for the current practice. I believe it's referred to as this is the practice. In prior cases, I think in one state it says they're not even sure where the doctrine originated from.
Excuse me, District Attorney Quinn, do we know where it originated in Massachusetts? Because
it's not clear to me that we do.
okay.
It's from the common law, but it's not delineated that it's from a specific part of our history or England. So frankly, I'm not aware of any precise, clear reasons for this doctrine, other than obviously the importance of the defendant's right to a direct appeal, which again, I'm not minimizing.
It is a long I mean, it goes back to Lord Mansfield, right? It comes from English common law. I mean, I'm not sure it's a good rule or a bad rule, but we do know where it comes from. It's an historic rule, right?
It's not clearly stated in the decisions, though, the basis for it. I agree it comes from the common law, but I don't think it's not precise in its origin or the foundation, a clear foundation for the rule.
What do you say about the defendant's position that the abatement ab initio, it's a procedural rule, it doesn't adjudicate anything, and in no way does the rule reinstate the presumption of innocence on Mr. Hernandez?
Oh, I mean, it wipes out the entire proceeding. It's a legal fiction. There was an indictment, a jury trial. It wipes everything out. That's not fair. That's not just when you weigh all of the interest. I'm asking you in the end to weigh all of the interest in the case. Maybe not one precisely, take one of the interests and say this controls, but there's a significant public interest. There's a significant interest from our judicial system in maintaining the integrity of jury verdicts absent error, or clear error that warrants a reversal. Now, obviously the defendant has died.
What rule do you want? I mean, there were a couple of different options presented. Would you be comfortable with the rule, the Alabama rule that simply states he was convicted at trial, he died while on appeal, and we don't say anything more than that?
Better than this rule, but I'm not comfortable with it.
And why wouldn't you be comfortable with that? Isn't that an accurate statement of where we are? So
It isn't
why is that not sufficient?
It could be. It's one of the options you could consider. What I'm trying to do is weigh all of the interest. Again, defendant has a significant interest. I don't think the Alabama exception is unreasonable because it states a fact, unlike abatement ab initio. The defendant is convicted, the presumption of innocence is gone, and we note on the file that he died before his appeal. That's all true. I mean, I don't think they're going to use that as a case, a precedent in upholding some other case. So I'm okay with that. I'm okay with the Kansas rule, I think in Hollister that talks about only allowing appeal in certain specific situations, significant state interest, guilt or innocence. That's better than this rule. But I'm not quite sure if that would really address certain cases that might warrant a review.
Best I can tell, the rule appears to be based on the view that you are entitled to at least one appeal. And the question then is, does a court grant the appeal and go through the motions of deciding an appeal for an individual who is dead with all of the cost incurred with regard to counsel for the defense and for the prosecution, as well as the burden on the court. And it appears that the rule essentially says we're not going to ask all parties to litigate a matter for a defendant who's dead, and therefore, because we're denying you an appeal, we're going to essentially dismiss the case. That's my best understanding of the basis for the rule. What would be your way of addressing the collateral consequences of the conviction if we were to pursue, say, the Alabama rule?
Well, I agree, I think, basically with your comments about the case. I'm advocating the Maryland rule, Sirlin versus State. And I think that's fairest to all of the parties to this matter. The defendant, the victims, society. It's probably the most important part of our system. Right to jury trial, jury speaking on behalf of the people, jury rendering a verdict. Obviously, if it's not guilty, we're not here. We're here because he was convicted. There's a significance to that in our society. It validates almost the integrity of the system, that a process took place and is validated not by me, the DA, maybe not even, well, the court could, and certainly in a jury waive matter, but it's representative of the people. For just to snap your finger and have that go away because the defendant died is not fair.
But Sirlin versus State, that sets up a whole subsequent process, right? Which we don't have even provision for, right?
Right.
We're going to have to hire counsel, figure out who's an appropriate person to bring such a claim. Why wouldn't the Alabama rule satisfy you? I'm not sure I get why that wouldn't be enough. It preserves the integrity. Well, it respects the fact that there was a trial and there was a conviction. It recognizes that it wasn't an appeal. It's not as if he were denied an appeal. He just hasn't had an appeal. And the collateral consequences for you, in response to the Chief Justice's question, what is the problem with the collateral consequences of the Alabama rule?
Well, the Alabama rule is okay for me. It may not be okay respectfully for the court, okay? I'm trying to create a middle route.
Well, the only reason it's of concern is whether it changes the collateral consequences, right?
Oh, he hasn't had a right to an appeal.
Well, he had a right to an appeal. He hasn't had the appeal because he committed suicide.
We talking about Hernandez?
Yeah.
Yeah. Well, there are several options. Leave it as it is. Let it stand at the other spectrum and just say it's a valid verdict without any other notation. The Alabama rule saying you've had your right to appeal, you decided, you're deceased, the presumption of innocence stays. You could have the Kansas approach that I referenced, only critical matters are subject to appeal, or the Maryland approach, which is a well-reasoned decision. Hernandez, there's a suicide issue in Hernandez. He committed suicide. That, if you found that the abatement ab initio is the practice, and that's the way, respectfully, we bake the bread, leave it alone, he committed suicide. it is fundamentally unfair to think a person could obtain in death what they could not obtain in life. That is, there could be some negative collateral consequences for the victim's family. There could be this notion that the whole conviction is wiped out because he took his own life. There may be other reasons why he did it.
This rule would extend, of course, beyond this individual case, which would.
Correct. I'm not just, yes.
Right, so if we follow this, and then we have a situation where an inmate is killed in prison before the direct appeal, could you address that?
Yes. I'm glad you asked it, because but frankly, I'm not really interested in the manner of death, because I'm advocating for Serlin. I don't think it's just that if someone takes their own life, that they are going to benefit in ways that they would not have if they stayed alive. Most likely having their appeal denied, but I'm not getting that, and other reasons. There's high-profile cases that years ago took place. John Salvi, he was convicted. He committed suicide, supposedly. There's a strong public interest in having that appeal heard. I don't care what the cost is. Appoint a lawyer, let it be heard. Strong interest on a number of fronts to validate, to vindicate that process, and let the conviction stand or not stand. The Gagan trial, that the priest was murdered in jail.
But doesn't that apply to every?
Excuse me?
I mean, that applies to every one of these cases. Someone's been killed, so I'm not
natural
sure why.
causes.
Why are you drawing distinctions between Salvi, Hernandez, Gagan, and others? I'm not sure I
Because
follow.
I'm not really, because in the end, I'm not arguing for a suicide exception. I want to have, well, however you die, you're deceased. Suicide, your own hands, natural death. Let's decide whether it's appropriate to have a review of the conviction. I think it is. I think it's worth the resources.
Under the substitution rule that the AG talks of and you talk of, wouldn't the default position in 90% of the cases be that it's a valid conviction, because there is no estate, really, when we deal with most people coming before the criminal justice system. So there isn't going to be anybody to press the appeal, and there is going to be no substitution.
That may or may not be the case. I want to see legitimate rights vindicated, if possible, defendant, Commonwealth. I don't want to see some poor soul who's got no estate, had a bad conviction, have the opportunity to appeal. So let's say there's no representative.
Right, the situation being, and I take this carefully because I was a trial judge, as you know. So suppose the instructions are woefully inadequate by the judge.
In which case?
So suppose a trial judge just gives wrong jury instructions. There's error. And in that situation where there is no estate, the presumption's going to be it's a valid conviction, and that issue would never be litigated, and the person never has a right to have that conviction overturned based on legal error.
I want to see it litigated. See, that's why if there's no estate, there's an appellate attorney in most of these cases, right, unless they die within days of the verdict, the appellate attorney could intervene and say this merits review. I frankly would ask you as part of the rule, do all murder cases on appeal. There's a significant interest from all parties to have some of these, I'm saying all the matters, but I mean, we're here, Hernandez was a high-profile case. That's not why the rule should be set, but it brings to light these issues. That's why we're here. In a balancing test, the court, I guess theoretically, wants to act in a reasonable way in reviewing these matters. That's appropriate. That's what it, this insignia says to some extent outside, a fair and justice. Justice for all is not justice for the defendant, meaning dismissed. Well, what about the strong public interest in vindicating a just conviction?
Well, let's talk about that for a minute, because as I understand your position, Mr. Quinn, and I appreciate it, is that we put our faith and we put our fate in the jury, and that the right to a jury trial is a pillar of our liberty, and
Yes.
has all sorts of important role to play with our social compact, and just eliminating that guilty verdict it can be pernicious, and we lose that vindication of a conviction. But what I don't really understand, though, is why, in response to Justice Kafker's question, why it isn't enough to do all that and have the docket reflect there was a guilty verdict. The defendant never had his right to an appeal and have it adjudicated, and just reflect on the docket the reality of the case. Why doesn't that affirm us, us putting our faith in the jury and the verdict? Why isn't that enough?
I'm referring to it as the Alabama wheat case. That's okay to me. I'm just saying, when I review this, I'm advocating a position that gives the defendant a little bit more of a say, so to speak, in the outcome of his case by advocating for the Maryland approach. If the court decides that's appropriate,
Gives the defendant's family, or it doesn't give the defendant's dead, so it gives his family the ability to do that, right? So you're focused on his family then?
well, the representative of the estate, his family, yes. I mean, that's how it's not a perfect process, and I might, if you give me in a few moments, it's not a perfect process. The person is dead who's a critical part of the case. In reality, he has very little impact on the appeal. I'm not trying to minimize it. That's a quote from Serland, not me, in terms of there's a trial record, there may have been consultation with counsel. I mean, what's he going to do, come in here and start arguing to you that something happened? I mean, unless he's pro se in that matter. But Alabama's okay. Indiana, the Hollister's okay. They're all better than what we have. I'm saying that Serland is a blueprint, a fairly recent case, that gives the defendant more protection. That is, he has the actual right to appeal, that there isn't just a notation on the docket. The Alabama case states the truth. I mean, it's not going to be argued that it's binding precedent, as I said, I don't believe. So Alabama's okay. They're all okay, except this might just be taking, I'm sorry, go ahead.
No, I wanted you to finish your
One extra step to afford the right to appeal. If the wrong jury instructions were given in Keith, Luke, or Gagan, or any case, but I mean, rectify it, or have the opportunity to rectify it. And that conviction is going to stand under Alabama, right? Bad jury instructions, they let in improper evidence.
No, well, but Alabama, the rule states he wasn't given a chance. It didn't happen. So the presumption of innocence has disappeared, but his rights on appeal have not been exercised, so we don't have a final conviction. And we haven't decided whether there was error or not in the trial. It's just an accurate statement of reality.
I agree. I totally agree with that. You can adopt that. That's fine. That's fine.
I understand your position that the fundamental line is that the abatement process is unfair to everyone.
Correct.
And that there are many options we can pick, and you've been trying to balance those interests and come up with a reasonable solution.
Yes.
One thing you said that I wanted to pursue is that you said maybe make a rule for all murder cases. And that's certainly, interesting. But what would be the rationale for distinguishing those from other serious cases or non-serious cases?
I would say probably, logically, in the end, none, because I can't say all these, but when you have, it just brings in the public interest a little bit more in terms of, that's when the public becomes in tune to the criminal justice system, especially in more modern proceedings. I'm not saying, a murder case is more serious in terms of the ramifications than a more lesser offense, but every case is important to every party. So I'm asking for a total rule, but why not review every case? We'd all be better off if the Salvi case, I'm just using those as examples, was upheld or not upheld. We'd all been better off if the Keith Luke case was upheld or not upheld. The Gagan case, maybe they let testimony in that shouldn't have been in. I wasn't there, but my point is there's a significant public interest in vindicating a just verdict or not. Now, there's a lot of details. There's more. This is more laborious.
There are practical consequences,
I agree.
too. The Enron case, for example, I don't know if you're familiar, Ken Lay
Yes.
died, and that was abated, and some of the victims did not get compensated because of that.
Not right.
No?
Wrong.
That's the wrong thing to do.
Right,
is what you're
wrong
saying.
thing to do.
Right,
And
yeah.
just an example, because that's a federal case, and I say this very respectfully, if the Whitey Bulger appeal wasn't litigated, my understanding on the federal, they throw that conviction out. Again, is that right? We'd have to look at the paperwork. I'm saying it's not, because it does not balance all of the interests of the parties, not just the victims, not just the defendant. Important, because I'm even advocating this Alabama rule a little bit more. Resources, it's worth it, because it's vindicating our system, okay? The application, and the workload. Frankly, I don't think there's that many of these cases. I mean, you would know, but I mean, I oversaw the prosecution of these cases for 8 years, now 12 years. I can't recall many of them. I don't know, there may be, but defendants are not dying significantly before their direct appeals are heard. One of the reasons I mentioned murder cases is those are the ones that are going to take longer to do the appeals. I believe, you know the docket, but I mean, they're big records. This Hernandez trial was 3 months. It takes time to assemble the record, I gather. Counsel gets assigned. So it's a minor matter, but the likelihood is in some of those cases that could happen. Maybe the ramifications of a murder conviction are more significant. But as I said, whether it's suicide, natural causes, Kenneth Lay, whether they're murdered. I mean, I don't want to get into an analysis saying, well, Aaron Hernandez took his own life, and it's a tragedy. This is a tragedy for everybody. This case and all these cases, we're dealing with human beings. Many people's lives are upended and, if not ruined, negatively impacted forever. I don't want to get into whether he hung himself for several reasons, one of which was maybe to help himself out, or whether he was murdered in prison for whatever the reason, or that he had a heart attack because the stress or whatever, it happened. So I'm advocating I'm saying balanced approach. Have Alabama, have Hollister, Justice Kafka. That only considers significant interest. Don't you have the right to review all first-degree murder cases? Do it. It's reasonable cost.
But
that's in the best interest of the society.
But doesn't the idea of having this litigation after the defendant is dead, it changes, the whole calculus and thought process changes, doesn't it? The stakes are different. The person has already died. So this kind of, subsequent, and also the defendant's not there to provide any counsel to the appellate lawyer doing this. It just seems artificial as opposed to just stating what happened and putting it on the record. The only real issue is the collateral consequences, and you haven't really addressed Chief Justice Gantz's question about that.
What specific collateral consequence?
The obvious example is the lawsuit by the victims for compensation, the civil lawsuit.
There's two aspects. You commit suicide and you're going to benefit from that in a civil lawsuit like the trial never happened? Unfair, plain and simple. Unfair. That no rational, reasonable person would agree that's fair, whatever the decision is. That's my answer to that question. And then the restitution, we're talking...
But the trickier question is whether preclusive effect is given to the trial decision, right? That's the trickier question because you haven't had the final appeal. Right,
yeah, I think so, but I mean, I think it can be given basic preclusive effect under Alabama, and again, these are all different options. Do nothing, let it stand. Those are the two extremes, meaning do nothing, let this doctrine stand, which has never been, as I say, clearly explained.
The precise question, though, for you is,
yes,
if we stick with the ab initio doctrine, right, then there is no, in a civil trial afterwards, there'd be no effect of the criminal verdict, absolutely none, right? Because
apparently
there would be no collateral estoppel effect. But if we do the Alabama rule or another rule, there may be some collateral consequences to the civil case, correct?
There could be.
Right, because then you may end up, you would have to address whether there is collateral estoppel effect to the original verdict, right?
Yes, but there's different factors in play here. I'm not like, that's a factor. There's other factors. I think the societal interest in maintaining the integrity of conviction is important. There's a lot of interest, including the defendant. In fact, one of these cases, I think the defendant wanted to go further in the appeal, and the court said no, like 30 years ago. We're going to abate your conviction. But my point is, respectfully, when I say do Alabama, that's fine. Do it. Do the other. I'm just trying to look at and broaden the spectrum, take I think a balanced approach. It is more work. It may be more entanglements. There's the rules of appellate procedure that provide a roadmap for appointing a substitute counsel, and I'm not talking about some zombie who doesn't care about the defendant. Standing in, that's a quote from a case, that doesn't care about, say, I don't like him, don't appeal. But that would be the defense, I'm speaking on behalf of the defendant in this case. So what I'm saying in summary is balanced approach, this doctrine makes no sense, respectfully. Yes, it is an important right at stake, defendant's interest in having his conviction finalized through a direct appellate appeal, but it's not always all about the defendant. There's other stakeholders that have an interest in the outcome of this case and just doing away with this proceeding. If I may, let me just touch on this.
Your time is up,
I
but
have 1 minute?
I'll let you touch on that
30
one last
seconds?
point.
Although none of the various approaches is perfect, this one, it seems to us, comes the closest. It preserves both the presumptive validity of the judgment and the ability of the defendant through a substituted party appointed for his or her benefit to maintain the defendant's challenge to it. It protects the interests of both parties and of the public generally, and because there are so few very instances in which the problem arises, should create no appreciable burden for anyone. No matter which approach is taken, the defendant who is dead can suffer no further punishment and reap no further reward, whether the judgment is vacated or not. I think that sums up my position. Alabama's fine. They're appropriate. This needs to change. Thank you very much.
Thank you. Mr. Thompson.
Good morning, Chief Justice Gantz, Justice Gaziano, Justice Lowy, Justice Budd, Justice Cipher, Justice Kafker, John Thompson, for the spirit of Aaron Hernandez. With me is my partner, Linda Thompson. This, I understand this to be the appeal of a ruling by Judge Garsh in the Superior Court on our motion, which was granted to abate the conviction ab initio. In the briefs and in this argument, there's no criticism of Judge Garsh's ruling. There's no claim that she made an error.
The issue is not whether she erred in terms she followed our
That's
case
right,
law.
she
The
followed
question
the
is
law.
whether or not our case law should be reconsidered.
Well, and there's no record made that covers the issues that are being raised here.
Could
That
ever
is-
be made to get a case, how could we ever have a proper record?
Well, there was an evidentiary hearing at which the Commonwealth was offered the opportunity to present whatever evidence it wanted to present.
But what
to
would we be looking for in that evidence? What kind of evidence should have been presented?
Well, for example, we're talking about, or the court and the Commonwealth are talking about the interests of victims or families of victims. There's nothing in the record that there was any.
So are you arguing that the general proposition that the Commonwealth is supporting, which is that this is an improper, or not an improper, but an unfair procedure, should just be limited to this one particular case and not apply to other cases, and that we can't consider broader questions such as the impact on victims in general or the public in general?
There is, in a common law case, the interests of the parties are paramount, and in this case, the interests of the parties should control the outcome. If there's an injustice, for example, as there was in Brown, it's an injustice to the parties, it has to be an injustice to the parties, and it has to be present in the facts of the case.
So in the
Then-
Ken Lay example, you see no injustice to either of the parties. So should have
That's-
been, the abatement should be okay.
I think the abatement ab initio is appropriate because it has a doctrinal basis. Now, this is not legislation, this is litigation.
Okay, so tell me the doctrinal basis, because I've read the law review articles on the history of abatement, and it just, some of it seems that there's no real good reason for it except convenience.
You have, as a fundamental doctrinal point in criminal law, you have two parties, the Commonwealth or the government and the defendant. The defendant is a unique, indispensable, and irreplaceable party in a criminal case. An appeal is part of the prosecution of a criminal case, according to Amirault. The Amirault case here, Justice Freed very clearly laid out the rationale for the finality principle that he expressed there, and defined how the interests of non-parties are taken into account. The doctrine does not say that non-parties' interests are not taken into account. It draws a boundary. It says that, excuse me, during the first phase, the pre-finality phase of a criminal prosecution, the defendant's interests are predominant. The defendant's interest in substantial justice is procedural. That is, we don't know who's guilty and not guilty. We rely on procedures to help a jury make a good decision about who's guilty and not guilty. But the jury's decision is not the end-all and be-all. It is an opinion arrived at by 12 people following a process that is subject to defects.
And I suppose one other question for me anyway is there no benefit to making court records consistent with actual reality?
There is a benefit, although what we know is that actual reality is a difficult thing to capture through a human-operated process. And so we rely on processes which sometimes have arbitrary effects, but the rationale is, or the calculation is, that overall, in the long run, adherence to processes and a rule of law brings better results and more reliable results than interjecting individual or personalized notions of what's fair and what's not fair, what's appropriate and what's not appropriate.
What's wrong with the Alabama approach?
What's wrong with it is that it has the effect of finalizing a judgment that hasn't been finalized. It's inconsistent with the Amirault principle of finality. That is, what Amirault says is that up to the point of the end of direct appeal, a conviction is an untested conviction, and guilt has not been finally determined. The Wheat approach.
But the Alabama approach doesn't say that guilt has been finally determined. It says that there was a conviction at trial, so the presumption of innocence has disappeared, but there hasn't been a final appeal, and therefore we don't make a final determination about his innocence or guilt. We just state that as a reflection of reality, and that's it. The real issue, I don't see, there can't be anything wrong with that, can there? It's not misstating the actual final result. It's stating what happened here.
The abatement ab initio rule does the same thing.
No, it doesn't. It says that it's as if this never happened. It's a legal fiction. It did happen.
It doesn't say that.
It does
Justice
say that
Kafker, if you look at the Superior Court order, it says, it's ordered that the motion to abate prosecution be and is hereby allowed. It is further ordered that the murder, unlawful possession of a firearm, etc., convictions be vacated, the indictments dismissed, and the notice of appeal dismissed. In other words,
As if nothing ever happened.
the fact of indictment is in the record, the fact that there was a trial is in the record, the fact that there was a conviction is in the record.
But they're all wiped out, right?
They're not wiped out.
Yes, they are.
They're right
as a
there.
legal.
What
as
would
a-
happen,
They're right there
counsel?
in the record.
What would happen hypothetically if there were a need to ever run a record check on somebody who had been deceased? How would this appear? Do you know on the,
All I know is what the docket says. The docket says that all these things happened. The docket says he was indicted. There were long pretrial proceedings. He was tried. He was convicted. He filed a notice of appeal, although the docket needs to be corrected on that. He filed a notice of appeal, and he died while the appeal was pending. And so all of these things were dismissed, but they weren't wiped out. They're right there on the record. The question is, are there going to be collateral consequences, that is, outside, say, in civil consequences? That's what we're really talking about.
counsel, what about an instance where you have a client who has been accused and tried and convicted, yet there is substantial concern or interest or evidence that perhaps he was totally innocent, and then the defendant dies? Isn't there an interest there in the defendant's family or society in having that brought out and resolved?
There may be an interest, that is, there may be people who are interested, non-parties who are interested, but their interests are not legally cognizable or judicially cognizable. That is, the judicial framework is limited.
Well, you're suggesting then that we're limited to the interests of the defendant, but we're also limited to the interest of the Commonwealth, is that correct? The prosecution?
That's right.
And the prosecution, what is the scope of their interest? It's a bit broader than just looking for a conviction.
The prosecution's interests are defined by the prosecution. That is, this is
Well,
a
the
political
prosecution's
entity.
interests are also defined by the Constitution, and they take an oath to make sure that the Constitution's followed and that they're looking for justice. They're not supposed to just be looking for a conviction. So if they're looking for justice, don't they have an interest then in making sure that justice was done?
They have an obligation.
Because the elected official for the area is representative of the people of that area, and they're saying we have an interest too in making sure this is correct.
That's true, and that is all accounted for in the current doctrine. That is, up to the point of finality, the defendant's interests predominate, as Justice Freed says in Emerald. At that point, finality, the government and the society's interest in finality, and that is in having things settled, kicks in, and the burden shifts. That is, now the defendant, the scope or the range of remedies to a defendant who's still alive are narrower. When a person dies, though, there are unavoidable consequences. When the defendant dies, there are unavoidable consequences. He's not the defendant anymore. There isn't a defendant in this case.
If I can focus you back on the collateral consequences,
Yes.
which is the practical effect of all of this. Put aside Mr. Hernandez. Let's imagine a case in which you have a defendant who has substantial means, who arguably may have had a life insurance policy for which it may matter whether or not he killed somebody in terms of who collects the proceeds. But let's assume it matters whether or not the person committed the crime. If the defendant were still alive, the alleged victim could simply waive the conviction and say, that conviction, Your Honor, satisfies my need to prove that he indeed committed the crime, and I don't need to prove it. But now he's dead. Under the current doctrine, that particular victim has to prove it as if the case was never tried. And I guess the question is, why should the victim have to do that where the case indeed was tried, the defendant was convicted? Why not simply say he can waive the conviction, but then the other side can essentially have some opportunity for an interlocutory appeal to get the appeal that would be necessary to render that conviction truly final?
If there were, well, let me start with Eisen, okay? Eisen is not the unreasoned opinion that has been characterized to be, as I've laid out in the brief. One of the things that Eisen does through Carter and Mazzilli is make the point that there is a separation between criminal and civil proceedings, and that where civil interests are concerned, these are not the interests of any party to the criminal litigation. The civil process is separate. And so in some circumstances, the civil litigants get the windfall benefit, perhaps a windfall, of a criminal proceeding that has been run to conclusion, and they have a collateral estoppel claim against a live defendant in a civil case. When that doesn't happen, for whatever reason, that's a civil matter. It's not a matter for the criminal court to be concerned with. That's what Eisen and the cases that it adopted in citing them as the basis for the rule, that's what Eisen says. Is that unfair? It is hard to say. It depends on the perspective that you adopt.
But in my and I mean, I'm struggling with this because we don't have any good options. In my example, it would be the burden in the civil case for the civil party who wishes to use that collateral, or the party who wishes that it not be used for collateral estoppel, to have the burden then of seeking interlocutory appeal to challenge it, saying, it's not fair, Your Honor, that this conviction is being used against my estate because we never had the chance for an appeal. And the consequence would be, okay, then we'll give you that chance to appeal, and you can appeal it on behalf of the defendant, and you can get the appeal that would render it final.
That would make it a civil matter completely, Justice Gantz, I would say.
It would be a civil matter to adjudicate essentially a criminal appeal. It would, I mean, it's unusual, I understand.
But it would not take
all of
place
this
in the
is
criminal
unusual.
case.
It would take place in the context of the civil case.
That's
yes.
right. And the civil litigants also have the benefit of having all of the evidence. The entire case is laid out and recorded. So while there's additional work in presenting the case, and there's the possibility that the civil jury might disagree, in most of those cases, the civil litigant, the civil plaintiff, has a powerful case handed to it by the prosecution. So it's not like the case is not there. It's that a shortcut has disappeared, a shortcut that was fortuitous to begin with, and it's disappeared in favor of the integrity of the criminal process.
But it's not insignificant. It was pointed out that this case took 3 months to try. So
Yes.
the issue of establishing the defendant's guilt here took 3 months. So in a civil case, albeit it would be by a preponderance, it could still be quite a considerable amount of time and effort to be able to establish that this defendant indeed was responsible for the murder.
But it happens, and it happened in the O.J. Simpson case, for example. And so these are,
Well, O.J. Simpson had no choice because there was an acquittal.
that's right. But my point is that there was a subsequent civil litigation in which the plaintiffs won and the defendant had to pay, or at least he was found responsible. So,
Attorney Thompson, may I ask you one final question for me, and that is, hypothetically, assuming that we agree the abatement process is outdated and does not serve the general interests of everyone at this point, which option of the options that have been presented do you think is the best?
frankly, I don't think that there is a viable option, Justice Cipher.
If you had to pick?
Probably the wheat option. But I haven't made a study of the available options. Those are the options that the Commonwealth presented.
Wheat is the Alabama approach.
Yes. I don't advocate that. I think it has some of the benefits of the abatement ab initio, which is a simple, easy to administer, and fair procedure that comes to a reasonable and just conclusion. That is, we don't have a defendant anymore. This litigation can't proceed any further. It wasn't pursued to the point of finality. Therefore, it's abated ab initio. It is not a judgment on the merits. The defendant is not vindicated. It has nothing to do with the presumption of innocence, which is internal to the trial only. And it doesn't disrespect the jury's verdict. The jury's verdict is still open to question in any appeal, and for very good reason.
Well, it does. I mean, you say it doesn't disrespect the jury's verdict, but it basically wipes out the jury's verdict. How is that not? It respects the appellate avenue, but it doesn't respect the jury verdict. It wipes out the jury verdict.
Anytime an appellate court grants relief to a defendant, it wipes out the jury's verdict.
Right, but it has to find an error. It doesn't just, if there's no error, then that jury verdict is upheld.
But it doesn't have to be the jury's error.
Right, no, I
That's my
understand.
point. The jury is not being disrespected. Their judgment is not being disrespected. The process says that the jury's verdict is an intermediate step in the criminal prosecution, and the final step is direct appeal.
Are there good cases that we should read that talk about abatement ab initio in the collateral estoppel context? Because a lot of the cases you both cite just deal with basically the rule, which is this ancient common law rule without saying, okay, how does it play out really in the civil context? Are there cases, good cases for us to read that explore that?
I'm simply ignorant on that point, Justice Kafker. I don't know.
Okay, that's fair.
Yeah. Well, Ms. Thompson, as far as the slate that we're writing on, you mentioned Eisen, and the briefs from everybody in this case have been really helpful. They were well done. But to go through the cases from Eisen to Barrows took me 5 minutes. They're all small rescripts. I don't know, interesting discussion on what Squires says about ab initio, and I understand your position really doesn't say anything about it. But it seems to me maybe we're not writing on a clean slate here. Maybe we're not writing on a clean slate. But it seems that as far as stare decisis, or something that's embedded in our system of justice as far as ab initio goes, this is not really one of those examples. There's a lot to this doctrine that hasn't been developed in our jurisprudence. So I guess, do you agree that, and I recognize everything you said about what needs to be done, like in Commonwealth versus Brown, to change the common law, but don't we have a little bit of room here, considering the lack of discussion of this issue?
Well, I would say, first of all, there's a very good discussion in the Minnesota Supreme Court's ruling in Burroughs, which is very similar to the interpretation of Eisen that we've laid out in our
I'm talking
brief.
about Barrows in our court back not that long ago. I think that might have been a rescript of 2 paragraphs as well. I don't think we've gotten past 3 paragraphs on this issue.
No, I'm talking about the Minnesota.
Yeah.
No, I think that Squires has and De La Zerda have substantial things to say about abatement ab initio, even though they don't directly deal with that. But we have, I think there are some.
But Squires goes against you in certain ways, because it doesn't just apply it, it resurrects the case to analyze the other defendant's case, right? Squires is digging a hole in abatement ab initio.
I don't think so, but I would say that to the extent that Squires applies to abatement ab initio, it might be saying that the interests of justice are not served when a conviction is let stand where there is insufficient evidence to support it. But the reason that the court, I think the reason that the court was free to make that decision is that it was not an abatement ab initio case. It was, this was on further appellate review. And there's another very important justice principle that's vindicated in Squires, and that's the Funches principle, that a party, especially when the parties have joined briefs, the parties in the same position should be treated equally.
Isn't Squires more on this line, the doctrine of you can't have your cake and eat it? You can't get abatement ab initio when it benefits you and when it doesn't? Because in Squires, of course, we resurrected the case and we allowed him to join his co-defendant for the reversal. But here you're saying it all gets wiped out.
I think that's correct, but I don't think that it was necessary to give Squires the benefit, except for the Funches principle, which has nothing to do with abatement ab initio, but it is, you've got 2 people in the same position, except of course that Squires was dead.
And since you're over your time, I'm going to ask you maybe my last question. Can you speak for just a brief moment about the interaction between counsel and defendant post-conviction, and whether or not it would be impossible to raise an ineffective assistance of counsel claim in this context where we can't consult with your client post-trial?
Well, I think that that ineffective assistance of counsel is the most prominent.
To my mind, that would be almost impossible to bring, correct?
It would be almost impossible to bring unless you have a case in which basically defense counsel confesses ineffectiveness during the trial so that it's on the trial record. Because of the...
Or near impossible, I should say.
The lack of factual development, which of course we're struggling with here too. There's the factual development is essential to a good appellate decision. So I think that you would say under, let's say, Amaralt, that an ineffective assistance of counsel claim in a Rule 30 is part of a direct appeal.
But this is a fair point, and the ineffective assistance of counsel issue is absolutely an important point as we look at all this. But there's nothing that's perfect here. And you mentioned de Lazerta. In de Lazerta, you had the further appellate review was allowed.
Yes.
And the defendant died before further appellate review was heard, and the ab initio doctrine didn't apply. So you couldn't have had really a well-developed, at least, ineffective assistance of counsel claim. So it's important. All of these issues are important on when we're writing on what I think is a pretty undeveloped slate. But that's not dispositive because you didn't have that in de Lazerta.
In de Lazerta, as I recall, this was a review of a Rule 30 ruling. But in both de Lazerta and in Amaralt, the court left open, noted that the definition of finality is subject to some variations. That is, like in Halbert versus Michigan, the question of when a defendant is entitled to counsel under the federal Constitution, the question is the issue being reviewed for the first time? Because it couldn't have been reviewed earlier. And so a good example, ineffective assistance of counsel example, is where where defense counsel fails to file a notice of appeal for a defendant who wants to appeal, and the problem isn't discovered until the time for enlarging the time for appeal has expired. The remedy is a motion for a new trial. And as the court has said in Price, the review of a ruling on that motion for new trial is a direct review.
Yeah, I understand. I'm just saying, my point is, I guess, much simpler than that, which is the doctrine is not going to apply if there's been direct appellate review or there's been even a decision in the appeals court. If you've had your appeal,
That's
then
right.
it doesn't apply. So that's going to mean in many cases, there might not have been an opportunity for ineffective assistance of counsel, and yet the conviction remains. I'm not saying that the ineffective assistance of counsel is not a good point, as Justice Gaziano raises it, but it can't be dispositive when we're applying this doctrine for that reason.
Well, one of the things that Amaralt says is this is where we strike the balance. There's a period, the first part of the litigation, we're concerned about substantial justice for the defendant.
Well, I don't know. I mean, Amaralt is an interesting choice. First of all, Amaralt, there's error, serious confrontation clause error in the case, and the conviction is affirmed, and Justice Freed quite poetically talks about the public interest and the community expression of condemnation in the case. So Amaralt is not the perfect fit here, because you have a very serious constitutional violation there, very serious, and the conviction is ultimately affirmed.
I'm not saying that abatement ab initio is a perfect solution. What I'm saying is that it is a well-founded in doctrine, workable, effective solution that doesn't work injustice on any of the parties.
What's the, I'm sorry, but what is the injustice of the Alabama rule? Where is the injustice in just speaking the truth in the docket?
I don't say that there's an injustice. What I'm saying is that it's not compatible with the rules, with the Amaralt doctrine of finality. That is, when a conviction is not final, and Griffin versus Illinois, which serves as the basis for the finality rule in the federal cases and in a lot of the state cases, say that the case has not been finally adjudicated, and therefore it's not fair, it's not appropriate, I would say, in the context of the system that we use to give it effect. That is, the effect is given once the direct appeal is over. You notice that when Justice Freed, in his Amaralt case, says that the public and the victim's interest in the verdict ripens when final review is given. That's when you can speak with confidence about the conviction.
Even though if we've granted further appellate review and the person dies, I mean, we don't grant further appellate review unless there's an important or troubling issue. There, that doctrine doesn't apply, at least at the Supreme Court level. So it's not, there's a certain arbitrariness to picking the first appeal as opposed to the trial, isn't there?
There is, and that is, a line has to be drawn somewhere. There have been recent...
So it's not, the line isn't being drawn for justice, right? Because there could be a mistake at the intermediate appellate level, right? The line is being, that line is fuzzy in certain respects too, isn't it?
Well, in a sense, but the way you use the term justice, Justice Kafter, I think makes a difference. That is, justice is the product of thinking that follows certain principles and processes that we all agree are designed to reach a fair and legitimate outcome. We have cases in the Superior Court where people are found, where defendants are vindicated after 25 or 30 years. I've had such cases myself. Those can't be touched by this kind of a doctrine. Those are unusual cases, we hope. They're certainly unusual in the sense of being found and rectified. But those injustices happen and persist, and we have processes and procedures that we follow in trying to find those people and set things straight. But for the run of the mill, this is the rule.
So in your view of this, the worst outcome would be the Alabama rule, because you'd rather have abatement or you'd rather have a full appellate process.
You
want abatement.
I'm defending the abatement ab initio rule because that's my job.
Asking you to go into a hypothetical realm for a moment and think about it more abstractly, and that is that abatement serves the purpose you're arguing, or a full appeal serves the purpose you're arguing, but the Alabama rule, which is this middle ground of just stating the facts, serves neither in nobody's interest. Is that?
I think that it's not clear to me what interest it serves. That is, I don't know, I haven't studied what impact it would have in collateral terms, that is on related civil litigation where the interests of non-parties or stakeholders or whatever you want to call them, the interests of non-parties come into play when they initiate the judicial process to vindicate their own interests in a setting where those interests can be judicially recognized and vindicated. I don't know what the effect of the Wheat Rule would have there. My feeling is that it would not have the finality that you would look for, say, in the case of Aetna versus Niziolic, where it seems to me that a final judgment is what triggers the right to collateral attack, or to collateral use, affirmative.
I'm not sure you're right on that. I think the way it works is that a judgment of a trial court will have collateral estoppel effect even if the person dies on appeal. So I think you've got it backwards, that ab initio wipes out any collateral estoppel effect, but under Massachusetts law, if you've got a trial verdict and the person dies on appeal, I believe the collateral estoppel effect is that it will have collateral estoppel effect. So I think it makes a difference.
Well, I haven't studied this carefully, Justice Kafker. I happen to know about the Niziolic case because we were counsel in that case. And I know that he had a direct appeal first. But I would make this point, and I think it's an important point for the purposes of this case. The civil law can be adjusted to account for however the court decides to deal with abatement ab initio. That is, it's not that this law, that the common law in these criminal cases.
So we could take the Alabama rule one step further and define what we think is the appropriate collateral estoppel effect of this type of consequence, which is the defendant dies while his appeal is pending. We could establish that rule, right?
Well,
So does that make
In
the
my
Al-
view
does that-
of-
does that make the Alabama more attractive to you then?
no, in my view of the common law and Brown and the way things are done judicially, there's no basis for changing this rule. But I would, the abatement ab initio rule, but I would say that the law of collateral estoppel is more flexible. The principles are less consequential, and the court, there's nothing to prevent in a case that comes before the court to say, in a situation like this, abatement ab initio, the conviction can be used collaterally.
All right. I think your time is up. Thank you so much.
It's been a pleasure.